Jacinda Ardern.
Mr. Speaker, I want to acknowledge the comments that are being made from colleagues on both sides of the House. And I think the Honourable David Parker made a very astute observation when he noted that for the fact that the 2006 Evidence Amendment Bill was really the first version of a consolidated bill to dictate and govern the use of evidence in court. The fact that this is our first attempt to review the Evidence Act following on from the Law Commission's work in 2013, I think demonstrates that the original drafting was actually very, very good. So I want to begin by acknowledging that. Other speakers have briefly touched on the substantive amendments that this bill makes. They include enabling more previous consistent statements to be admissible in evidence. We had quite a bit of discussion around the way the law dictates the use of admissible consistent and inconsistent statements to be used in the court. Extending the privilege that currently applies to settlement negotiations and mediation in civil proceedings to include plea discussions in criminal proceedings. I think it's useful here to clarify that the Evidence Act is really just stipulating what is already practice. And that is privilege covering plea discussions in criminal proceedings. But this did, when I read this, it did trigger something that I wanted to use this opportunity to put on record. Plea discussions in criminal proceedings. Plea discussions, as what has been termed by others as plea bargaining in the New Zealand justice system, is not new. We do not adopt plea bargaining when it comes to sentencing, but when it comes to discussions in criminal proceedings around charge, it does happen. It has happened for some time. It is not new. It has, however, been somewhat controversial in recent times, and I would argue for good reason, because some fundamentals of our justice system have changed. And that includes I would say the way that legal representation is incentivised to operate. In 2009, the legal aid system moved to what the government probably would have deemed to be a more cost-effective way of working. It's moved to a fixed fee for legal aid lawyers that has resulted in an absolute decline in the availability and accessibility of legal aid lawyers on the one hand, but on the other, questions have been raised around the quality of the legal aid assistance and advice that people are now receiving as a consequence. As the Criminal Bar Association Vice President said, I think it was last year, quote, "You're incentivised to do a shoddy job, to enter a guilty plea at the fastest moment, to cut corners and cut everything to the bone because there's no way you can do the work in those timeframes. But because the system hasn't imploded, the ministry assumes all is well." I just want to use this opportunity, given that this was, in part, the Evidence Amendment Bill allows plea discussions in criminal proceedings to, for all intents and purposes, remain privileged because they currently in practice are. These discussions around entering guilty pleas, we have anecdotally had fed back to us, are occurring on a much more frequently because the system has incentivised that to occur. Now, sometimes that will be appropriate, and sometimes that will stand in the way of a person accessing the full ambit of the justice system. It may stop someone even from accessing the ability to go before the court and argue against a charge that they haven't committed. So, Mr. Chair, this is fundamental to our justice system, and I just wanted to use that opportunity to raise that it's our view that it's time we absolutely reviewed the impact of the 2009 law reforms. Mr. Chair, I want to come to two more substantive parts of the evidence bill, though, that has been touched on briefly, but I want to expand on just a little bit. They're both changes that we absolutely support. One, though, is the creation of a presumption that all witnesses under the age of 18 shall give evidence by means of other than sitting in the courtroom. Absolutely support that. Anyone who has sat through the court process has been a witness in a case or been a jury member will know what an intimidating and difficult environment that is for anyone, let alone a child. A lot of thought went into how to make sure that we got the balance right in that change, and I think the Ministry of Justice has done a good job in conjunction with the Law Commission. But the second element is the bill's move to require Defence Counsel to give advance notice if they intend to bring evidence about the sexual history of the complainant in sexual offence cases. Look, we know that 1 in 5 women in New Zealand will experience a serious sexual assault. Those numbers are staggering. But on the flip side of that, we also know that only 10 out of every 100 sexual abuse or violent crimes are being reported to the police, and even fewer than that are coming before our court. Now, we have to look at the full ambit of the way that those cases are treated from the moment they're reported to the police right through to the way they're processed through the courts. But when it comes to the process through the courts, we know, of course, that the ability to bring up sexual history in the court process obviously acts as a form of deterrent. There is no doubt. So the question then becomes, how can we deal with that in a way that allows full access to all of the aspects of natural justice before a court, whilst also balancing the very important needs of the victim as well. And I think that on balance we've got it about right. But I wanted to reference that in 26 July 2009, there were media reports of the dire consequences of defendants being able to bring up sexual history in a court can have on a victim, and if that victim is deceased, indeed on their family. And there is no better example than the Sophie Elliott case, where it was reported that there was visible distress from friends and family in the courtroom. Sophie Elliott's mum, quote, said, "I still feel upset her life was played out there so publicly." Now, it was argued by Simon Power at that time that getting rid of the provocation laws would reduce the likelihood of sexual history being raised in a court in the way that it was in the Sophie Elliott case. I actually don't think that would have been the case, even if that defendant in that case wasn't using the provocation defence. I imagine that would have been used anyway. So we do need a provision like this. And this section, as it's currently worded, will mean that the interests of justice will require the evidence of sexual history to be excluded unless the case for inclusion can be made. So the balance sits on exclusion unless the case can be made to the judge that it's reasonable to include that evidence. However, there is a bit of an exclusion, and that's when it covers evidence of a complainant's sexual history with the defendant. Now, I think we need to keep a close eye on the way that that is utilised. So I want to just refer to what was one of the Ministry of Justice statements on this part of it, of the exclusion. It said the Law Commission did not consider it appropriate to expand Section 44 to cover all evidence of a complainant's sexual history, and reasoned that cases involving a prior sexual relationship between the complainant and defendant overwhelmingly turn on the issue of consent or belief in consent, to which a prior relationship will almost inevitably be relevant. Now, we know that in a number of cases of sexual violence will involve someone that the victim knows. So the likelihood of the exclusion here around a complainant's sexual history and relationship as it relates to a defendant is likely to be enacted on a reasonable basis. As infrequently. So I think it's incumbent on us as a parliament to make sure that we really keep an eye on the way that this provision both works and the cases where it hasn't applied, to ensure that we've got the balance right in the way that Section 44 applies. So it's something that we need to keep a keen eye on. But ultimately, all of this is likely to be re-examined when we have before the Parliament again the government's formal response. We saw a quick response to the Law Commission's report on alternative trial processes for sexual violence. We probably need to look at all of this again as a whole when some of that substantive report comes out. And I think it's very likely, hopefully, that we will be debating the option of both court processes and non-court processes, and giving victims greater choices around how they pursue cases of sexual violence against them. So look, all in all, I think the process around examining this bill has been excellent, a good example of a select committee working well together, and a really helpful report from the Law Commission, Mr Speaker.